Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is Acquisitions or Not? Big Tech's Big Problems Investing in Artificial Intelligence. At this point, it's really old news that horizontal mergers, vertical integrations, and strategic investments by big tech companies are undergoing higher levels of scrutiny than we've seen in decades. Today's episode was inspired by an intriguing blog post in which our guest begins with a blunt observation. If you work in big tech, forget about acquiring an AI startup unless you want to go through a long and hostile review process. But what happens when a big tech company doesn't actually attempt to acquire an AI startup while getting most of or all of the benefits of an acquisition, whether that means access to talent or technology? The merger clearance rules don't apply, but as our guest today has written, that hasn't stopped the agencies from investigating the potential anti-competitive effects of these non-acquisitions. Before hearing more about that, though, I'd like to welcome my co-host, Anant Raut. Hi, Anant.
Hey, Alicia.
Anant, would you like to introduce our guest and kick off the conversation?
Sure. Luis Blanquez is a partner at the Bona Law firm with over 15 years of experience at the European Commission and major international law firms. He previously served on DG Comp's merger task force, where he investigated a number of major tie-ups, as well as the Directorate General of Information Society. Currently, he is the Vice Chair of the Distribution and Franchise Committee of the ABA Antitrust Law section. Welcome to our Curious Amalgam, Luis.
Thanks for having me. Pleasure to be here.
Luis, AI has been the buzziest of buzzwords in the tech sector for almost 2 years now. There are a number of startups in this space getting a lot of attention. They're also getting a lot of investment capital from big tech companies, which has drawn the attention of antitrust enforcement agencies. Maybe you can start us off by telling our listeners who's being investigated, by whom, and why.
Well, big tech, they've been all in the crosshairs of the antitrust authorities under the Biden administration for the past 4 years. Why? Well, mainly because two of the pillars from the Biden administration's antitrust policy have been an aggressive merger enforcement agenda and its crusade against big tech and vertical integration. So you can imagine the suffocating level of scrutiny big tech companies are subject to whenever they try to make an acquisition these days. Combine that with the AI wild race we are all witnessing lately, where big tech companies are trying to position themselves as future market leaders of the AI market. So then it's very easy to picture Nadella at Microsoft, PJ at Google, or even Cook at Apple, asking their lawyers to find the best way to get cutting-edge generative AI technology without having to go through a painful and hostile merger review process. In other words, how to avoid a formal acquisition and instead use agreements with startups to get the technology and talent they need to stay on the leading edge of AI. And this is actually what we've been seeing lately. So you've seen, for example, in March of this year, Microsoft entering into a deal to license the technology of Inflection, a company launched in 2022 to help consumers use a PI, a personal intelligence app. You've seen also similar deals involving OpenAI. Both Microsoft and Apple have a relationship with a company that gives them access to its generative AI technology without having to use an acquisition to get it. The DOJ and the FTC are also looking into similar partnerships involving generative AI companies such as Anthropic and major cloud service providers such as Amazon and Google. More recently, we've seen two additional examples of similar transactions by Amazon, including Covariant and Adept AI. Last month, the startup Character AI also signed an agreement with Google, granting the latter a non-exclusive license to the chatbot maker's LLM technology while poaching its co-founders who rejoined Google, where they were formerly employees, together with some of their key people. And last but not least, let's not forget about the new big elephant in the AI room, NVIDIA. NVIDIA has done 4 transactions in the past several years, And also this month, the DOJ has started an antitrust investigation to discuss the terms of its contracts and partnerships. So the investigation focuses mainly on concerns that NVIDIA's acquisitions of RAN AI will make it difficult for customers to switch to other chip suppliers, and that NVIDIA uses supply and pricing to penalize customers that don't only buy its chips. So as you can see, there is a lot going on in the AI space, and not only in the US.
So let's talk about the competition theories of harm. In the 2023 merger guidelines that the FTC and the DOJ introduced, Guideline 11 is about partial acquisitions that don't result in control, but may nevertheless present significant competitive concerns. Is that the issue here? Are the agencies concerned that these big tech companies are effectively acquiring their AI competitors in a way that circumvents the Hart-Scott-Rodino reporting requirements?
That's a complicated question that antitrust enforcers will need to answer soon. I can give you some thoughts here. First, HSR applies to two kinds of acquisitions. First, acquisitions of voting securities of corporations or the equivalent, or for entities like partnerships or LLCs. But in these transactions, no such acquisitions are made. So no HSR filing would be necessary for that reason. Second, HSR applies to acquisitions of assets, a term undefined in the HSR regulations. But in the interpretations of those rules, never has a hiring of particular human beings, even important ones, or plenty of them, been considered an acquisition of assets. Certain exclusive licenses have been considered acquisitions, but never non-exclusive ones though. So again, no HSR filing necessary, at least for now. And yet, these reverse acqui-hires seem to be the sort of transactions that could change competition that HSR was designed to cover. And that's why the agencies are very interested in these deals, actually. And maybe just one final thought here. Section 8 of the Clayton Act prohibits, as you very well know, certain interlocking directorates between competing corporations, meaning no person can simultaneously serve as an officer or director of competing corporations, subject obviously to certain jurisdictional thresholds and de minimis exceptions. So one of the many challenges enforcers are going to face here is who is a real competitor in the AI industry, something not easy to determine in this nascent and rapidly evolving market. So, as you can see, a challenging path for the antitrust agencies to find a way to consider these transactions as acquisitions for HSR purposes.
And I'll just ask this question for listeners who might not be following this news as closely as you have. We've certainly seen the news in the legal press and sometimes even in the mainstream press about the existence of these investigations, along with various levels of detail about the nature of the transactions that are being investigated. Has anything emerged, though, that would provide us with a real idea of where the agencies are going with these types of theories and what specifically they're most concerned about? Would it be the theory that these are de facto acquisitions that, while they may not be reportable, should be judged by merger standards? Or is it something more like a traditional monopolization inquiry?
We haven't heard much either from the US or even the EU. Probably their best shot is going to be to consider the hiring of particular human beings as acquisition of assets. That would be my guess. But we have to wait and see what they say in the coming weeks or months, probably.
What do you think the effect of these investigations might be having on stakeholders other than the companies directly involved, such as venture capital investors and AI startups generally? This is something that you touch on in your blog post.
Well, as a startup in the tech industry, and really in any industry, your main goal is to either try to eventually go public through an IPO, or if you become big enough, or rather look for one of the big tech companies to acquire you, right? The problem with we have here in the AI industry is that antitrust agencies' current appetite to block these transactions had an impact on venture capital companies and investors thinking twice before risking their money on a startup. Because unless they know that the company is going public, they really, they're thinking twice whether to put their money on those companies and when to do it. Just to be honest, how many companies they go public out there. Not only in the tech sector, but in general. This is an important issue for investors and venture capital companies.
But that's the nature of venture capital investing, right? Like the antitrust enforcement agencies are not the small business administration here trying to make money for investors. And another argument that you discuss in your blog post is this harm to innovation, which I think is a straw man argument in this case. The agencies aren't saying these companies can't take money from anyone. They're just saying we are concerned when these startups are taking money from other companies that have products that compete in their space.
So now we have a little debate going. Luis, what do you think about Anant's point? The fact is, I think both sides are trying to promote innovation. The antitrust agencies would say they're trying to do that by ensuring fair and free competition. And as you've pointed out, but without the capital, who's going to fund this innovation?
So on the one hand, you see antitrust enforcers arguing that these reverse acqui-hires might stifle innovation by preventing AI startups from growing independently, while at the same time, big tech avoids antitrust regulations, so consolidating the market power they already have. And in the past, the problem, I think this is coming because in the past, antitrust regulators failed to move quickly when faced with the rising market share of now dominant tech platforms like Meta, Google, and Amazon. So now the enforcers want to make sure we don't have another big tech 2.0, right, scenario, where big tech could be shaping the AI landscape thanks to their vast resources and market influence. But on the other hand, the landscape for AI startups is increasingly challenging. So the development of AI systems requires significant investments in costly hardware, data infrastructure, and key talent. So the reality is that building leading AI models is extremely costly, and raising hundreds of millions of dollars isn't even enough for them to compete these days. Big tech, meanwhile, have their cash reserves full and ready to invest in the AI industry. And by the way, besides, let's not forget that poaching is good for competition, right? So the FTC non-compete rule that was issued, when was that? On April of this year, I believe, was broadly banning non-compete agreements nationwide. Although it was recently, I think it was a couple of days ago, that the federal court stated that such rule exceeded the FTC's rulemaking authority. But anyway, that's probably a topic for another podcast. So
it certainly has been. That's right.
Mm-hmm. So just because
doesn't this come down to a much simpler question of why do these companies have to take money from these particular big tech investors? There are hundreds of billions of dollars in venture capital money floating around in this country. And this idea that has been offered that, these investments don't change our decision making. Look, if I borrow $15 from somebody, that changes my decision making. I'm not going to post that photo of me eating an ice cream cone on Instagram because then that person's going to say, well, I guess you only needed $11.50 of my money. And then on top of that, these startups who are also offering big tech board seats, the dial-in to their board meetings. And for all the talent that they have acquired, it's almost malpractice that they have not been able to offer a plausible sounding explanation for why are we taking money from direct competitors in this space? Why not just get it from other venture capitalists?
Well, I think it's because you need to have the know-how, you need to learn about the technology, and it's a very specialized industry, I believe. So not everyone has the ability, the knowledge, or the experience to invest in the AI market.
All right, Luis, let me jump in on the other side of this argument, which is, are the agencies maybe jumping the gun in investigating this industry? And the reason I ask is that the AI space has a lot of hype and a lot of money in it. But I would argue that the actual consumer-facing generative AI product is not that good. AI has failed to transform any major industry. Yes, OpenAI gets $2 billion in subscriptions every year from ChatGPT, but you can't leave ChatGPT unsupervised. The output of generative AI is not reproducible enough, accurate enough to transform anything. And you take the example of Amazon, which has a cajillion dollars, but they couldn't develop their own AI internally. They are licensing Anthropic's AI for their subscription Alexa model. And to use one other example, take cryptocurrency. 4 years ago, cryptocurrency was where AI is right now. Everyone was talking about it, a lot of hype, a lot of money in it, promising to be transformative. But it turns out there wasn't widespread adoption. The two primary use cases of crypto remain as a speculative asset and facilitating illicit transactions. But had the agencies jumped in at that point and said, well, this crypto coin can't merge with this crypto coin, we would maybe look back on that and think that was kind of a waste of resources. Are the agencies looking at the AI market as that market exists today or around the hype that exists around the AI market?
Well, there I would say that we are at the stage where things are certainly on the making, but the technology behind the AI industry, in particular as far as large language models is concerned, is developing at a light speed. So, and a good example is the recent ruling on the Google search case. So I don't know about you, but in my case, I rarely use Google search anymore. So I'm using ChatGPT for my research when it doesn't come to legal issues, of course. When it comes to legal research, you have the traditional Webflow, which are developing also other AI models and tools to work with. But my point is that it would be interesting to watch how, and coming back to your point as well, how disruptive ChatGPT is going to be able to become in the general search engines market, as well as Google's AI strategy in the same market in the coming years, because we have to see it's evolving really fast, and it's a nascent market today, but it's gonna grow exponentially. And something that is new today is going to be consolidated very soon, and we have to see whether it will be maybe a few large language models out there, or there will be plenty of them. I think there was a study from the CMA, the UK Competition Authority, where up to today there is up to, I think, 200 large language models available. Still, we have to see whether it's going to be towards having more language models, or they're going to be a consolidation of all of them, and we'll have a 1, 2, or 3 that will survive. So yeah, it's very difficult for the competition authorities to intervene nowadays and determine what's going to happen. But at the same time, they have the fear of what happened with the online platforms in the past. It's a difficult balance for them to work with.
And we've been talking about what the U.S. competition agencies are doing. Can you tell us what's going on in other jurisdictions and competition authorities outside the U.S.?
Well, actually, antitrust authorities all over the world are also analyzing these same cases. And of relevance is the European Commission and the CMA, the UK Competition and Markets Authority. So the CMA in particular has been investigating the AI foundation models and has published several reports explaining its antitrust concerns in the AI industry. If I remember correctly, in its report, the CMA identified several partnerships and strategic investments within the foundation of AI chain involving digital firms, which the CMA believes already have strong positions in related markets. So the UK regulator has noted that these partnerships and investments result in stronger relationships among firms at different levels of the AI supply chain, and that may require financial investment and provision of key inputs, such as data or compute, as well as distribution agreements on an exclusive or priority basis. So basically, the CMA is concerned that these partnerships may allow big tech to exercise control and influence over multiple parts of the AI value chain.
Well, that's certainly a concern that seems to be echoed here in the United States. But with the recognition, as I think both of you pointed out in your own ways, that what they're trying to regulate is something of a moving target. We don't know where it's going to wind up. We don't quite know where it is day to day. It doesn't necessarily have to transform society or any particular industry to warrant regulation. Any final thoughts?
Well, bottom line, this new approach raises important questions about whether it will lead to a more vibrant and competitive industry, or rather consolidate power among a few major players. So the future impact on the balance between innovation and consolidation of existing power from related markets in the AI industry is currently a mystery, and one of the most fascinating topics in the antitrust world today, for sure.
Well, I agree. Thank you, Anant and Luis, for an interesting conversation. Now we're going to get to know Luis a little bit better as a person. So, can you tell us something interesting about yourself or something surprising about yourself that is completely outside of your professional life?
Probably two things. The first one is the fact that they've been outside from my home country since I was 22 years old, so more than 20 years now. My idea was to just go abroad, study for 1 year in France to finish my law degree. And one thing after the other, I started studying there, then working in France, and I went to Brussels, to Belgium, where I started working and get interested in antitrust law. Went to Amsterdam, went back to Belgium, then went to London, went back to Madrid, where I met my wife, who happened to be from San Diego. And after that, we moved back to the US, to San Diego, where I'm based now. I prepared the bar exam here in the US, so now I'm able to practice law in the US and in Europe. Basically traveling, and how much I enjoy just meeting people from all over the world, from different countries, learning, what they do, food, cultures. It's something fascinating. And the second thing is the fact that I became a girl's daddy just a couple of years ago, and she's been teaching me. I knew a little bit about the world, but once you have kids, especially in my case, it's a whole new world of everything, experiences, feelings, and everything else. So probably those two things.
Oh, that's very sweet.
Congratulations.
Thank you.
Now, before we let you go, however, we're also going to play a little game that we call the Curious Hat.
And now it's time for the Curious Hat!
The rules of the game could not be more simple. I'll ask Anant to draw a surprise question out of an entirely virtual hat. So take it away, Anant.
Luis, what is your favorite sport and why?
Well, actually, believe it or not, is basketball. Even though I'm not tall at all, I'm actually short. When I was a kid, I was a very good basketball player. And my idea or my dream was to play for the national basketball team. And I did some tests in the very beginning, and I was kind of good enough, but then I didn't grow up enough, and they just told me, you're not tall enough, so I couldn't join them. But I've been following basketball since I was a kid, and once I moved to the US, well, you can imagine, the NBA is very big in this country, so it's basketball for sure.
Favorite team?
I would say the Lakers. Many people are gonna go onto my throat, but probably Lakers.
Well, that's fine. They're a great team. Thank you so much, Luis. And thank you, Anant. And thank you to listeners. Tune in for next week's Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.